and also how to go about them. Please put your questions within the Q&A. As the presentation proceeds, you don't have to wait for the end of the presentation. As soon as you see an area where you want to ask, please post that in the Q&A at the bottom of your screen. So as we talk about this thing called DPIA, it mainly relates to where we're processing different types of data, more especially personal types of personal data. And this is just a list, non-exhaustive, for what special personal data entails, from biometrics to any profiling of individuals. On the right-hand side is the list from the Privacy Act on what they call special categories of personal data. Things to do with racial, ethnic origin, political opinions, health data, medical information, final information. So this is just a dashboard, an exhaustive list of examples of personal data that we'll focus on for the next few minutes. The context for today is the data protection impact assessment. This one has specific triggers and requirements under the Data Protection and Privacy Act. In this case, I'm talking about Uganda's Act. And it's different from a normal privacy impact assessment. That one is done mainly to assess areas of non-compliance with provisions of the Privacy Act. However, this one here is more specific in nature, and it's triggered under certain provisions under the Privacy Act. In Uganda's case, we find this in the regulations, Regulation 12 specifically, which states that where the collection or processing of personal data possesses a high risk to rights and freedoms of natural persons, then the controller or data processor has to undertake a data protection impact assessment. And the guidance here is that this has to be done prior to the processing of that personal information. So that's the requirement here. So the trigger is right there within the regulation. That's the context for today's presentation. Now, again, when I was looking around, this is the same, even in other jurisdictions, the GDPR also in other countries, I've seen the same terms and the exact wording, which all relates to high risks to rights and freedoms of natural persons. And someone might ask themselves, what are these rights and freedoms for natural persons? So the rights, the Privacy Act provides certain rights to data subjects who are also natural persons. And those are the rights there that they do have. But also, when we talk about freedoms of natural persons, globally, the most common ones are the right to liberty and security, respect for private life, right to property, freedom of movement, and things of that sort. So it combines a balance of the rights and freedoms of natural persons, which we have as data subjects. But also, even beyond privacy, there are other things and the freedoms of that. A natural person expects the right to life, right to liberty that do apply. So in the context of this, when a risk is posed to such rights and freedoms, then the data controller or data processor has to undertake this data protection impact assessment. That's the context for today. Now, the risks that arise, mainly that this assessment tries to kind of reduce. We know that we're largely using technology for most of the processing we're doing. And in terms of using IT or technology-driven systems, there is no way you can reduce your risks to zero. You only reduce the risk from happening. So you put in as much effort, as many controls as possible to reduce the risk from happening. Now, because this data exists in a digital world, it's very easy for it to be abused, misused, or even accessed by people that are not authorized. And that would have serious implications for the data subjects. And these are the risks. One is discrimination. which might arise if the information is not used when it comes to processing, for which, as I will explain, areas around identity theft or fraud, if this information is accessed by a criminal element, or if it is sold or stolen, then that can create an issue for identity theft. And some of these things are reversible: financial loss, damaged reputation, like I'll show, loss of confidentiality of personal data, because there's no way they're saying that internet doesn't forget. So when people see things, you can't easily unforget. So loss of confidentiality of personal data is another risk, and also adverse outcomes. In this case, this includes things such as fines, cancellation of entitlements, all as a result of the collection or use of their personal data. So these are the risks that a data controller or an organization will be reducing once they implement the data protection impact assessment. So a definition of this, given the context and the risks. So a DPIA this assessment is mainly a process, and it's aimed to identify first the risks to the rights and freedoms of natural persons, and also to reduce those risks arising out of the processing of their data. So it's two-way, double-edged. One is to identify the risks. The second is to reduce the risks arising out of that. The main components of the DPIA are that one, it describes the processing of personal data. It assesses the necessity and proportionality of processing, and also manages the risks and freedoms of natural persons. This is what would be entailed within the DPIA. In Uganda's law, the regulation requires that a controller has to undertake this process. However, it does not say that you have to submit it to the Data Protection Office. We've seen in other countries, for example, I've seen some people on the call from Kenya. In Kenya, it's mandatory that you do have to submit this DPIA prior to processing to the commissioner's office. In Uganda's case, this is something you do and you have on your record, which comes in handy in case the regulator comes to do a spot check, or even for you to demonstrate accountability to your stakeholders, to your clients, that you have taken in consideration using the most maximum way to protect the risk of their data. So there are different ways, different triggers. This is just a list of things that a controller or an organization can recognize and then rely on this to start the DPIA for the organization. So if there is any activity around profiling or scoring, then would expect that those would be grounds for someone to raise a start for a DPIA. Just to give a little bit of insight on profiling and personal data, if you're using, let's say, the ways that people do this, examples offered that when people use innovative technology, in this case, AI, things like artificial intelligence, to try and profile or predict information. There are examples here that we've seen happening where profiling can be used to predict information about a person. For example, personality traits can be predicted from standard mobile phone logs, such as call logs and contact data. Publicly accessible data points of an individual, for example, tweets of an individual, can be used to infer a person's location. And based on that location, someone can use that to estimate your average income based on the neighborhood, or even other information around that. In another case, we've seen researchers who are able to use cell phone usage history to predict socioeconomic status of an individual. When it comes to scoring, we've seen some people using scoring to determine people's suitability for employment, analyzing an applicant's voice. You can predict the energy, personality of an individual and use that to assess them. So some of these things we call them invisible profile or scoring. Or for example, e-commerce sites that use a lot of data points from a user and to determine what price of a product is offered to you or what type of a product. In this case, it could range from the type of operating system you're using. Are you using an Android phone? Are you using an iPhone? If you're using an iPhone to access an app or website, then most likely you might get higher prices and things of that sort. So where an organization is using is undertaking evaluation, profiling, and scoring that can trigger this. Automated decision making, systematic monitoring that I'll explain. If you're in any way collecting special personal data, like the types that I raised at the beginning, then you need to do a DPIA before you start that business operation or organizational activity. Processing data on a large scale, and this one has different metrics around it that I'll explain as well. Data matching, if you have personal data that you're collecting, but then you're matching it with data from another source in order to take a decision on a client, then that also can trigger a DPIA. If you're using information, personal data, for secondary purposes, beyond the original purpose for which it was collected, then that also triggers a DPIA. And also the obvious one, as long as you're disclosing data outside the organization, then you need to do a DPIA, even if it's based on contractual grounds or terms guided by law. You still need to do the DPIA to make sure that the risk to the rights and freedoms of the natural persons is not affected, which is the main focus of privacy. Other triggers include where an organization is going to introduce a new system. If they've been using an old system, or if they've been paper-based, and they're now going tech, if it's cloud-based, on-premise, so that technology introduces new risks, which do attract a DPIA or any type of sharing of data. For example, if you get new business partners on board, then you're going to share information with them. If that's the case, that will also attract a data protection impact assessment. I talked about this earlier. When you use data for a new purpose, for which it was not originally collected, then this also attracts a data protection impact assessment. Now, beyond technology, companies may make some policies or strategies that have privacy implications. If a business is taking on a new venture, or you're increasing scrutiny, let's say, of your KYC process, and that's a decision from the board arising out of an audit committee saying we need to increase how we do KYC. Maybe you want to add more information or go extra lengths to verify KYC information using other data sources. Then, even at that stage, making just that policy decision will also attract a DPIA. So it's based on quite a myriad of issues that an organization will have to consider, obviously guided by the data protection officer for that organization. The ICO has an examples of practical examples of areas where DPIA can be applied. Innovative technology, in this case, this touches processing using energy technologies, innovations, AI, machine learning, market research, involving neural measurements. All these do attract denial of service. If you're going to take a decision about a client, whether to give that client a service, so you're either denying the client or the applicant to get access to that service, or you're accepting, then the DPIA is also comes into play. Things do credit checks, mortgage or insurance applications, loan applications, and other pre-checks, any other pre-checks related to contracts where special personal data is involved. Large-scale profiling, like we mentioned, I earlier mentioned around social media networks or using AI in existing business processes. For organizations that have a lot of biometric data, using facial recognition, access control, genetic data. If you're collecting this other than that processed by a medical practitioner or a clinic outside that scope, then it also attracts the DPIA. Data matching for fraud prevention or direct marketing, monitoring personal use for all uptake of services, that also attracts the DPIA. Those are grounds as well. And then also the last aspect, which is on invisible processing. And this is with list brokering, online advertising, where an organization is using publicly available data. Then also these are grounds that may attract a DPIA. Tracking is increasingly happening, mainly activated by COVID-19, where organizations can now track their employees or tracking individuals' geolocation, behavior relating to an online environment, and using software technology to achieve this. Things around loyalty schemes, like we've seen them around as well. Different businesses here do have loyalty schemes where they collect personal data. So that also applies, attracts the DPIA. Wealth profiling for financial institutions also does attract that. Now, where there's a risk of physical harm, again, this will attract a DPIA, and this is mainly information around whistleblowing, complaint procedures, or social care records. You've seen this, I think, when the US exited, I think, Afghanistan, and the Taliban got access to the biometric data for contacts that were working with the US, so they're able to trace people as well as their families. And here we're talking about real life risks of physical harm to life. Remember, one of the greatest freedoms of natural persons is the right to live. So in areas where you collect information that can cause risk of harm, this is mainly for state organizations, then this has to be taken into consideration. The regulations have further guidance on what a DPIA is. In Uganda's case, there are three things that the regulation says have to be included in a DPIA. So if a regulator was to come and assess, they would expect to find the following three mandatorily covered within the DPIA. The first being a systematic description of the envisaged processing and purpose of the processing, the risks to personal data, and also the measures to address those risks. The office can also give guidance from time to time when it as relates to types of processing where personal data can apply. So when they do give that guidance, they would expect to find that in your DPIA. So for now, since that has not yet happened, would mainly expect to find the first two, which is the description, the risks, and also the measures to address such risks that have been identified. In addition, what we see in addition is the same in other jurisdictions. The additional element we find is around necessity and proportionality of the processing operations in relation to the company's business. Now, a question I get asked more often is who should conduct the DPIA? Well, this has to be done by the data controller. In the Act, the data controller has all the risks. They can't delegate them. They own all risks since they determine the purpose for the collection and processing of personal data. So the data controller should do this DPIA, and we know most data controllers have appointed data protection officers. So the data protection officer, in this case for organizations, will be able to lead this engagement within their organization, doing this in collaboration with their internal teams, because the teams are the ones that drive most of these operations where it comes to. use of personal data. If it's a government agency, then there are teams that do that. If it's a bank, there are teams that do that. If it's a fintech, a hospital, a school, or a church, there are process owners who want this information. So the DPO in that organization has to guide that internal team on how to go through this process, making sure that it's correct, and at the end of the day, that is aligned to the regulation. It's also allowed and encouraged to use independent experts of different professions. You need guidance from a legal expert or from a cybersecurity expert or from a risk expert. So adoption of this adds credibility to the reports, especially if it has a lot to do with special data. So this is who should conduct the DPIA. The best practices, the DPIA should include a description of the processing, where an organization has to describe the type of processing that they're undertaking and ways in which they are complying with the Data Protection and Privacy Act, as well as the regulations as they have described. The second is best practice is to look at the description of nature of processing, and again, the DPO has to take lead and guide the organization to make sure that they are following, they have properly described the nature of the processing to show the flow of information, where the information is stored, who has access, people, third parties it is shared with, the security controls around that, and any other technologies to do that. All that is part of the nature. Risk assessment is straightforward, which I'll explain, but this is mainly looking at the risks that might arise, as earlier mentioned. So the risk may be low, it may be medium, it may be high. That needs to be assessed and accepted. Then measures address the risks. If risk has been identified as high, then we would expect to find measures that bring that risk lower to the lower acceptable level. And obviously, all this has to be documented, and it's a continuous process and attracts a periodic monitoring and evaluation to make sure that at all times the rights of data subjects is observed, but also there is no harm to their freedoms and other rights that they have as human beings. So we earlier talked about describing how the data processing complies. Describing the processing will need to see an explanation of how the processing complies with the following principles: lawfulness, fairness, and transparency, how information was obtained, which legal basis did an organization rely on or is relying on to collect this information. Consent is one of the legal bases, but it's not the only one. There are other things which exist, such as if it's required by law or if it's for entering into a contract. The other ways, there are around 5 or 6 areas for lawfulness, there's fairness and transparency. Capacity limitation is also an area that has to be described. Data minimization, here the check is just for people to double check, double think through and see, do they really need all that personal data that they want to use? Can they still achieve the same objective without the special personal data? So that's an area where that would be answered. The accuracy of that information, accountability, which demonstrates the lawfulness principle. Now, what the nature of processing includes a description of the flow, how information flows from the point it's collected, where it is processed, where it is stored, where it's archived, who has access to that data at all those touch points, where could the data be transferred. If it's out of the country, the Privacy Act has guidance where that is acceptable and where it's not. Which parties are involved in the processing, what are their specific responsibilities, where third parties are used. Do those contracts include contractual clauses to protect access to the data? Because in Uganda's Act, the data controller bears liability in case of a breach or that might lead to exposure of personal data. And if that breach leads to people realizing those risks happening to them, then the controller here is answerable. So one tool for a controller to reduce that risk is making sure they have those standard contractual clauses that they protect access to that data if it's a third party. Never state any other governance documents that support the data processing. Things to do with information sharing agreements. I guess it's a multilateral organization that operates across different countries and they share some platforms like it is in IT shared services. Then those have to be in place to make sure that all grants have been covered. Now, the risk assessment is mainly again to look at those high risks and see if they exist, and if they exist, how they can be treated. Now, a risk, I'll just go high level. It includes when you're assessing risk, you look at the likelihood of harm and the severity of the harm. So you might find the likelihood of harm occurring out of the profiling you're doing is low, and if that information was breached, then the impact might be low. It might be low, high, medium, high, or high, high. So this is only determined by looking at the likelihood and the impact, which is the severity. So the combination of this reveals the risk score, which an organization has to look at and decide how to go about it. This is a simple table which can be used at that time for the risk assessment. The first part, this is just a template for guidance. We look at describing the source of the risk, the problem it creates, and the potential impacts on individuals. In the next row, you look at the likelihood. Is it remote? Is it possible or probable? The severity. This is more the impact. Is the impact minimal? Is it significant? Or is it severe? So the combination of that will lead you to identify the risk score, and then the organization has to take, the process owner has to take a decision. If it's low all the way, then that can be accepted. However, if the risk is high, then one of the options could be to mitigate that risk. The other option could be to avoid and you say, okay, this route, we're not taking this route, let's go back to scratch and stop at that. If you choose to mitigate, then the agreed action, including who will do it, and also the controls, the date and time are also indicated, so that this is part of accountability to show that it has been well thought through and the process owner has participated to accept the risk, to mitigate it or to avoid it or transfer the risk, but also more importantly, that at the end of the day, all the risks have been reduced and managed. So this DPIA doesn't remove risk, it helps to manage the risk and reduce the risk from happening. The benefits to an organization, the first is obvious. This minimizes risks as much and early as possible because the regulation is clear. It says this has to be done prior to processing of that special data. It helps in identifying strategies. Looking at the previous templates or table I showed, by the time an organization goes through that, then they are clearly identifying strategies which will help to achieve the project goals without impacting on privacy. DPIA has also helped to demonstrate compliance with the privacy laws as relates to the processing of special personal data. Definitely, if risks are reduced, then you're also reducing future costs that could be taken in terms of management time if a breach occurs, the legal expenses of going through the hassle of cleaning up a breach, the court cases, the fines and all that, and also the potential negative publicity. So this is kind of, the DPIA kind of future-proofs the organization against such costs and such expenses. When this is done for new projects that are coming on, for new technology that is coming on, for new services, that are coming on. When this is done frequently, in the long run, this improves awareness across the organization and improves the understanding of privacy issues, the privacy risks, and puts the organization in such a place where they are now becoming privacy compliant, but also at the end of the day, meeting the rights for us and as individuals, the rights that we have, and also the freedoms that we have as individuals. At the end of the day, get to meet that in the digital world, since this is where most of the processing is being supported in this day and age. So that's the highlights of the presentation of the overview of the DPIA, how it runs, and its benefits that can be realized as well. So I thank you so much for listening, and we're open now to questions and answers, or comments or inquiries that you may have out of this presentation. Thank you.
Okay, thank you very much, Emmanuel, for that informative and educative presentation. We have some questions. Some are in the Q&A panel and others are in the chat. So I'm going to be reading them for you as you respond. I'll start from the Q&A panel. Someone says Regulation 12.3 states that the office shall establish and publish operations that require DPIA. Has the office come up with this list yet? If not, are we expected to do anything as we wait for the list? Back to you.
For the question, I want to allow me to pass on that question to Mr. Baker Berikuja from the Data Protection Office, or Angela Tugumi.
Okay. Baker, are you on the?
Okay, well, as they come online, the guidance here is that the regulations require you to do it now. So the office, the regulations allow the office to describe operations, types of operations or processing that are subject to DPIA, but the first two clauses require you to do this on your own, so you don't have to wait for this. The other one will mainly come into guide, but the requirement now is that you do this as long as, in your opinion, or as long as guided by your data protection officer, that whatever you're doing attracts certain high risks to the rights and freedoms of data subjects, then the law requires that you must do this, and it's mandatory. So you don't have to wait for the guidance, you just have to start now.
Sorry, Emmanuel, my microphone had issues. Can you hear me now?
Yes. Yes, we can hear you.
Oh, okay. You wanted me to provide clarity?
Yes.
Just a minute. Please proceed as I work out some.
Okay, we'll come back to that. We can proceed to the next question.
All right, the next question is, who approves that DPIA? Is it the board or senior management?
Okay, that's a good question. So definitely data controllers have, if it's a company, there's a CEO, if it's a government agency, there's a ministry, there's a permanent secretary, and if it's, so whoever heads that organization, the head of that organization is the ultimate risk owner. So they will be the ones approving that DPIA. After it has been done and filled in by the teams, then the ultimate approval of that is the person who is in charge. So that's the head of that institution. So the CEO or the MD has to approve that.
Okay, thank you. I hope you have been answered. The next question is, how often is the DPIA submitted to the DPO? Is it a biannual, annual, and when risks are noticed? I think he meant PDPO. The question says, how often is the DPIA submitted to the PDPO? Is it biannual, annual, or is it when risks are noticed?
Thank you for the question. So the DPIA, you do this when only in circumstances where the high risks, and this is more on special personal data. That's the time that you do it. Based on the presentation went through, there are certain triggers that do ask only to you to do a DPIA. So you only do that as often as you acknowledge that there's a certain high risk. And we gave the examples. If you introduce a new piece of technology, which is going to significantly change how you're processing special personal data, then you do a DPIA. If it's a new service you're doing, a DPIA. If you're sharing this information with someone else as part of a new business service or a new technology innovation you're using, profiling, as long as in your scope of business you are using special personal data, then you do that DPIA. The law doesn't require you to submit it to the office. It requires that you do this and have it and make sure that it informs your operations. You may submit it to the office. In Uganda, you're not required to, but I've seen some people from Kenya on this call. In Kenya, yes, you have to submit this to the Data Protection Commissioner.
Okay, thank you. Another question is, can you please give a clear example of that DPIA?
Thank you so much for that question. The presentation focused a lot on the process. Because giving an example, I'd have to look at a particular company or business or operation that's happening now. If you had something in particular, then I would be able to guide you through that, share how it works.
Okay. For those asking about the recording, this meeting is being live streamed and you'll be able to get the link. The next question, I think Stanley had already shared this with the Q&A panel, so you've already answered this. So someone asked, are there templates for the DPIA? Anonymous participants. Yeah, are there templates for the DPIA? That's the question.
Yes, the templates, there are no templates for the DPIA because it's a process and it's unique to every organization. The nature of processing is different. So the focus is on the requirements that have to be put in there and the process. And this comes from the regulation. So this slide here shows you what you have to do. So it doesn't prescribe a template. The regulation says what you have to include. So whichever way methodology you use, you have to show you've done that systematic description of the envisaged processing or purposes of processing, and you have to have done a risk assessment and also included the measures to address those risks. So the guidance here is what has to be included, and it's up to the data protection officer in that organization or the expert that you're using to guide on this. But there are practices that can be used from other, for corporate organizations, they already have enterprise risk policies, which they can apply the same methodology to achieve the same purpose, or using the other standards around ISO. So the focus of the law normally doesn't prescribe a template. It describes what has to be done in order to achieve the same outcome. So whichever way you do it, you make sure that you are answering these mandatory requirements as required in the regulation.
Okay, thank you very much, Emmanuel. I do not see any other questions. Members, if you still have a question, we are going to be ending in a few, so you should be able to post it in the Q&A panel. In the meantime, Becca, are you there? Becca, are you on the call? Okay, I don't seem to see Becca. I think he has left. Unless someone has something else to say. Okay, I don't think anyone else has something to say. For those that have been asking for the presentation and the recording is available on YouTube. I'm going to be able to share with you the link. The presentation will also be shared with you as well. We are having a launch. We are launching the PDPO portal on Tuesday, 31st of May from 9 to 11. Kindly be there and attend. I am going to share with you the link. Yeah, please register in time so that you're able to attend. Thank you very much. I do not see anyone with a question. Very much, Emmanuel. It has been such a very wonderful session. And the rest of the members, thank you so much for attending. Till next month. See you then. Have a blessed day.